Swayam Prabha. Digital India. Educated India.
Good day everyone and a warm welcome to all our viewers. I am delighted to have you join us for this engaging and enlightening journey into the world of the jurisprudence. I am Dr. Simranjeet Kaur, Professor and Principal School of Law, CT University Ludhiana. In today's lecture, we will discuss Leslie Green, The Concept of Law Revisited. So let's embark on this intellectual journey together and uncover the fascinating world of legal theory. So let's start with the topic. Law is a social construction. It is historically contingent feature of certain societies, one whose emergence is signaled by the rise of the systematic form of social control and elite domination. In one way, it supersedes custom. In another, it rests on it. For the law is a system of primary social rules that direct and appraise behavior, together with the secondary social rules that identify, change and enforce the primary rules. Law may be beneficial, but only in some contexts, and always at a price, at the risk of the grave injustice. Our appropriate attitude to it is therefore one of the caution rather than a celebration. Law pretends also to an objectivity that it does not have for whatever judges may say. They, in fact, wield serious political power to create the law. Not only is the law therefore political, but so is legal theory. There can be no pure theory of law. Concepts drawn from the law itself are inadequate to understand its nature. Legal theory is thus neither sole preserve nor even the natural habitat of the lawyer or law professors. It is just one part of the journal, social and the political theory. We need such a theory not to help decide the cases or defend clients, but to understand ourselves, our culture and our institutions, and to promote serious moral assessments of those institutions. An assessment that must always take into account the conflicting realities of the life. Those are the most important theses of late H.L.A. Hart's. The Concept of Law, published originally in 1961. Like some other great works of the philosophy, however, Hart's book is known as much by the rumor as by reading, so it will be unsurprising if to some that does not sound like Hart at all. For what circulates as his views, particularly I am embarrassed to say in the law school, is often quite different. Isn't Hart the dreary positivist who holds that law is a matter of rules that rest on a happy social consensus? Doesn't he think law is objective, a matter of fact? Doesn't Heart celebrates the rule of law and takes its rise as an achievement, a mark of the progress from the primitive to the modern society. Doesn't Heart think that liberty and justice are possible only through the certainty that clear law provides? And isn't his whole theoretical perspective straightened by a disproved or at least outmoded distinction between the fact and the value? Isn't Heart concerned more with the semantics than the politics? Between those conflicting readings, maybe I should say attitudes towards Hart's book, there also lies a realm of consensus about the way the concept of the law changed the directions of the Anglo-American legal theory. For one thing, it introduced and clarified a set of questions that came to dominate the literature. Is law always coercive? Which are the legal rules? Do judges have the discretion? Is there a necessary connection between the law and the morality? Hart always and also coined the idiom in which we debate the answer to such questions. The practice theory of the rules, the internal and the external point of view, primary and the secondary rules, the rule of recognition, core and the penumbra, content, independent, reasons, social and critically morality. These terms and distinctions are now part of the cultural literacy for the legal theorists. Writing in English, how then can there be such a wide divergence in the view about Hart's theory, such confusion about his central claims? It is impossible to put it down to style. Hart is a clear and an honest writer. Every technical term is purchased in the coin of necessity. The occasional obscurity of the language is never a cover for the shallowness of a thought. Humor and irony he used to lighten, not conceived. In part, it may just that geologist has moved on. The concept of law is the book of its time. The book's language, examples and the methods rest in England and more specifically Oxford of the 50s. Here I want to try to bridge the gap, not only as I have done in the opening paragraph by connecting Hart's concern with some recent ones, but also by re-examining the 1961 work in the light of some themes in its newly published postscripts. The second edition of the concept of law consists of the original text together with the reply to the critiques that Hart left unfinished at the time of his death in 1992. The editors Fenipol, Bulick and Joseph Raz have done an invaluable job of preparing this postscript for the publication. Two parts were projected by the Harts. The first, published here, is mainly a reply to the criticism of Ronald Dworkin. The second, which never got beyond fragmentary roles, sought to counter other critiques, Raz among them, no doubt, who Hart concedes found points of incoherence and contradiction. In his work, Hart chooses to add a postscript rather than revise the text of the book, because, as the editorial note, he did not wish to think with the text whose influence has been so great. It is not, of course, as if the Hart waited 30 years to reply to his critiques. He was a lively polemicist and points out the refinement in the postscripts are less significant than the number of the essays he published after the concept of law. The postscript brings no major surprises or recension, and some of the heart's responses to Dworkin are already well established in the literature. There is no categorical distinction to be drawn between the legal rules and the principles. Principles can be comprehended in the rules of the recognitions. Judges do exercise discretion even when they carry forward by analogical construction the underlying spirit of the law. For at the same point, a choice among analogies cannot be avoided, and positivist legal theory has never been a matter of semantics. Here, I want to focus on some other points. In particular, some of the heart's last thought about rules, power, the connections between law and morality, and about the nature of legal theory. For there we find some of the most enduring theme and problem of his work. Law as a social construction, anti-naturalism and anti-essentialism. Constructivism is now widely popular in the social studies, where the term has expanded to refer almost every anti-realist or anti-essentialist or anti-determinist view of the social life. Some of this argument is substantially idle, for its challenges no descriptive or normative thesis about its object. If everything of interest is social construction, if there is no unconstructed reality, then nothing follows from claiming that something is a social construction. Race is a social construction, and so are racism, poverty and bullets. This might sound like a potent theory, but it is not. It is like being told that God does not exist, only to find out that the interlocutor does not believe in the existence of the dogs either. Once we lose the term of implied contrast and everything is on an ontological par, there is no critical bite to the claim. At a lesser level of generality, constructivism sometimes simply amounts to the thesis that the object in the question has a history. Here we need to distinguish the claim that our discourse about an object has a history from the claim that object itself does. That the word electron was invented in 1890s does not suffice to show that electrons were. The significance of the constructivism about our object of inquiry depend on whether anyone might deny the later thesis. It is trivial to speak of the social construction of intolerance, as it is undeniably obvious that tolerance and intolerance are matters of human thoughts and practice. It is more interesting to speak of the social construction of race because many people still believe that the classification of people into races is a natural one. The constructivism challenges that belief. The most potent forms of constructivism are thus those that promise to surprise us with the news that a certain object of attention owes its very existence to a social history. Should we thrill to hear that law is a social construction? If this is just a consequence of the journal thesis that everything is constructed, or that the word law is then we more profitably may pass on to the other business. If it is the claim that law is a phenomenon with a history, then we will have at the every least a challenge to certain arguments that associate law with the reason out of time. with what P.F. Strawson once called the core of a human thought that has no history. Some forms of the ancient and medieval natural law theory might then be under the threat. Hart's theory places law firmly in the history. According to him, that there is a law at all follows wholly from the development of the human society, a development that is intelligible to us, and the content of the particular legal system is a consequences of what people in the history have said and done. Moreover, he maintains that even the normativity of the law, its action guiding and the action appraising character is a social construction to be understood as a function of the people's action and their critical reaction to the behavior of others. For Hart, however, there is all part of the specific nature of law. It is not merely a consequences of some form of general philosophical normalism. He theorizes law as a social construction, but it is one that emerges in the field of unconstructed reality, including ever certain unconstructed constraints of the human condition. It is tempting to see Hart's constructivism simply as a reflection of his positivism, but that would be wrong. For one of the most sophisticated positivism and one whose influence on Hart was significant denied parts of the constructivist thesis. Hence, Kelsen held that law is a system of norms which are not historical things at all. Kelsen did think that jurisprudence should restrict its attention to the positive law, human law rather than natural law, but he did not study the law under its empirical aspects. Rather, he proposed to study it as a system of norms that, according to Kelsen, exist only if it is valid. Validity in turn entails the bindingness. In other words, that people ought to behave as the norms require. Historical facts, such as fact that someone said this or ordered that or was disposed to behave, thus can never validate norms, for an ought cannot be derived from an. So, the reason for the validity of the norm can be only another norm, and thus the ultimate reason for the validity of law must be a norm rather than a matter of fact. This transcendental logical presupposition Kelsen called the grand norm. So, while Kelsen is the positivist, law may have any content and there is no necessary connection between law and morality. He is not social constructivist. For Kelsen, law as a norms is not really part of the social realm at all, and the tools with which we study historically situated norms, sociology, psychological, political theory, economics, etc., are for him all alien elements that lead only to the adulteration of the pure theory of law. For Hart, in contrast, law is a social construction in two senses of the term. First, law has a history. It is an institution that did not always exist, that emerged for the special reasons, and that takes the form it does, including its normative character, only as the result of the human action. In fact, law is a social construction of social constructions, not of a brute facts, but of the institutional facts, namely rules comprised by the social practice and enforced by the social pressure. Second, Hart's resulting concept of law is anti-essentialist. Though there are central cases of the legal system and central features of those cases. There are also borderline cases and analogical cases when without improperly we still may speak of law. For heart, there is no essence to the phenomena we call law, and although legal theory is right to strive to understand law's central feature, knowing these will not give us the key to all the sound. Generalization about the legal system, there is no essence of the law, the understandings of which can replace the hard historical sociological or, if you like, genealogical task of explaining law as a social phenomenon. Thus, although the term would be foreign to him, there is no coherent way for which a legal theory to the more constructivist than Hart's law and the social rules. One familiar hesitation about the social constructivism and its attendant suggestion of constructing or building a reality is that it sounds all too deliberate and volitionist. Gender is a social construction. Some even say a performance, yet people sometimes feel bullied and constrained by the gender roles, and these roles often seems to resist revision. Giving adequate weight to both agency and structure, to the willed and the unwilled, was one of the Hart's major tasks in replying to classical positivists. Law said Thomas Hobbes, Jeremy Bentham, John Huston are the expression of the will. They are the journal commands of a sovereign. But as Hart saw, such a conception of law cannot explain the variety of the forms of law, nor how sovereign can be bound by their own rules, nor how law survives the death of the commander. Above all, it cannot explain the normative character of the law. The fact that it purports to impose obligation on us. A person say so has such normative power only when what person somehow is authorized to make norms. Most sovereign bodies are of course legally authorized to make the laws, but we need to explain the laws authorizing the sovereign as much as any other law. So, if there is a norm or norms at the root of the legal system, it cannot be legal norm. Then what is it? Hart rejected Kelson's theory of unconstructed, unsocial grand norm and its mysteries. Instead, he argued that fundamental law-making power rests on a customary social rules and has the kind of the normative force that such rules have. Law, Hart argued, it's a union of social rules, primary rules that guides behavior by imposing duty on the people, and secondary rules that provides for the identification, change and enforcement of the primary rules. Among the secondary rules, the so-called rule of recognition has special importance. A customary practice of those rules, it is identify and apply primary rules. The rule of recognition provides ultimate criteria of legal validity by determining which acts create the law. The rule of recognition itself is neither valid nor invalid. It simply exists as a matter of social fact, or it does not. But when it does exist and when people use it as a standard for appraising behavior, then the language of the validity and invalidity comes to life and a legal system is born. Consensus, domination and the power. So, law for Hart is socially constructed from the rules, which are themselves constructed from individual practice. That may sound to some like a rather complacent and comfortable view of an institution, that is an instrument of the social control. For accepted social rules are sort of the things that we ordinarily find in the discredited consensus theories of the social functionalist and the system theorist. What about conflict and power? Hart's Whig history. It is unfortunate that Hart introduced the concept of law through a somewhat wooden fictional history of social development, breaking the change from what he sometimes called a primitive form of community based solely on the rules of obligation to a different form of social organization based on the primary and secondary rules. It is perhaps these passengers more than only others that have contributed to the undeserved reputation as an enthusiast of the rule of law. For on a casual reading, it seems like Whig history of progressive from primitive to modern, from custom to law. On this reading, we begin with the primitive society in which social order rests on the broader consensus about so-called primary rules of the obligations that are maintained by diffuse social pressure. But these societies are static, inefficient, and fraught with uncertainty. Law emerges to maybe even emerges in order to cure these defects. Thus, in developed, complex society, things are better. We gain certainly dynamism and efficiency through the introductions of the rule of recognition, change, and adjudication. That is common reading, but it is mistaken, and the mistake easily can be corroded one's understanding of Hart's theory. So let's take it to move slowly. For Hart, primitive here just means simple. The reason that such societies do not have the law is that they do not needed it. Nothing in the human nature or society requires that we may have law. Many people have gotten along well without it. A legal system with its institutionalized means of social control is not a necessity but a luxury. What then does Hart mean when he speaks of the defects that the secondary rules cure? It is crucial to his argument that simpler form of social order do work, but only in certain contexts. He writes, only a small community, closely knit by ties of kinship, common sentiment and belief, and placed in a stable environment, would lively successfully by such regime of unofficial rules. Despite this real viability, any other condition such as simple form of social control must prove defective and will require supplementation in different ways. It follows then that the defects that the law remedies are not defect in simple, transparent form of social order, they are in a sense defects in us. These problems arise when we try to apply those informal solutions native to the world of transparent solidarity to a world of a few or repudiate kinship ties in which sentiments are not shared, in which the environment is not maelstrom of the change, where, as Marx says, all that is solid melts into the air. So Hart's target here are not simple, transparent form of social order. It is the mistaken drive to apply techniques of governance appropriate to those targets to a more opaque world of strangers, the mistake of a Rousseau or some of the modern communitarian political theory. It is also the mistake I think of Dworkin when he suggests the political obligation may rest on fraternal obligation of the community. Elite domination. Hart argues against the John Austin, who helped a top-down pyramidical view of the law as the order of the sovereign, generally obeyed and beckoned by the threads. It commonly is acknowledged that Austin was a crude theory, but some feel that it was at least realistic, and that Hart, while making positivism more subtle, also loses its punch. For now, law must rest ultimately on a form of social consensus, and that idea obscures the way in which law in fact is rooted in social power. To sum up, a theory about the nature of the law must account for the internal point of view. It must explain the sense in which participants regard the law as a reason for their action, and what are the kinds of purposes or the values that would render such reasons intelligible. But this is still a form of understanding, not judgment. We can understand various forms of the practical reasoning without forming any evaluative judgment about them. And if we do not need to form a judgment about such reasoning, then jurisprudence is still basically descriptive and morally neutral. So, I thank you for your time and attention. I look forward to our next session, where we will continue to explore the fascinating concept of jurisprudence together. Thank you.